In our last lecture, we explored the ideas of the Declaration of Independence. We saw that the United States is the only nation established on a basis of principles, not of ethnicity, geography, accident of history, but of principles. And the foundation of those principles is the idea of natural law. The new nation justified its very independence by an appeal to the laws of nature and of nature's God. Now, in later life, Thomas Jefferson would claim no originality for the language and ideas of the Declaration of Independence. Indeed, he stated quite rightly that its authority rested in the fact that the Declaration of Independence was an expression of the American mind, the harmonizing sentiments of the day, whether expressed in conversation, in letters, printed essays, or the elementary books of public right, as Aristotle, Cicero, Locke, Sidney, etc. Now that etc., in Jefferson's later words, have led scholars to think that these names, Aristotle and Cicero, Locke and Sidney, are just throwaway terms. Nothing could be further from the truth. Jefferson was stating that he had two fundamental traditions. One, the unique legacy of England, hence Locke and Sidney, and the common legacy of all of Europe, Greece and Rome, Aristotle and Cicero. Nor are the names picked randomly. Locke, the man of ideas; Sidney, the patriot who goes to death for his views; Cicero, the Roman patriot, the man of ideas as well as actions, who, like Sidney, will die for his belief in liberty; and Aristotle, the professor, the man of ideas, the teacher of Alexander the Great. So these are very powerful names brought forth by Jefferson. And we want in this lecture to explore this common legacy of Europe from Greece and Rome that is the idea of natural law. It was an idea born in the intellectual ferment of Athens, born in our first set of lectures with the Athenian democracy, the first government based on government by the of the people, by the people, and for the people, rooted in the idea that every citizen was capable of handling any governmental position. The intellectual genius of Athens would bring forth the idea of natural law, but it would be the administrative and legal genius of Rome that would transform it, formalize it, and pass it on through Christianity and into the world of John Locke. So we start with the Roman lawyer, statesman, and patriot Cicero, so admired by the founders, who gives us what is still the best definition of natural law. In his work on the Republic, composed between 55 and 51 BC, Cicero writes, "True law is right reason in agreement with nature, universal, consistent, everlasting, whose nature is to advocate duty by prescription and to deter wrongdoing by prohibition. Its prescriptions and prohibitions are obeyed by good men, but evil men disobey them. It is forbidden by God to alter this law, nor is it permissible to repeal any part of it, and it is impossible to abolish the whole of it. Neither the Senate nor the people can absolve us from obeying this law, and we do not need to look outside ourselves for an expounder or interpreter of this law. There will not be one law at Rome and another at Athens, or different laws now and in the future. There is now and will be forever one law, valid for all peoples and all times, and there will be one master and ruler for all of us in common, God, who is the author of this law, its promulgator, and its enforcing judge. Whoever does not obey this law is trying to escape himself and to deny his nature as a human being. By this very fact, he will suffer the greatest penalties, even if he should somehow escape conventional punishment." Thus, for Cicero, natural law is divine law. Natural law is rooted in a belief in God and in absolute right and wrong. It is our responsibility to obey this law, and there are the most grievous consequences for breaking the law of nature. This law is truly universal. It reflects the divine harmony of God's universe and of nature. And because of this, natural law is the law of reason and common sense. Nothing which contradicts man's natural reason and common sense can be a true law. Reason is our most human quality. It is what separates us from animals. And through our reason, we perceive natural law. And the informed conscience of the individual is the means by which we understand the law of nature. The law of nature, God's law, is higher than any laws made by man. And no human institution can absolve us from our obligation to obey natural law. Now, the idea of natural law began in the intellectual creativity of the Athenian democracy. It began in the words and ideas of the sophist. But when it first makes its appearance, the law of nature means something very different than we find in Cicero. It means instead the law of might makes right. It is the law that the sophists saw acting in nature itself, by which the strong already rule the weak. It is the idea that comes through forcefully in Thucydides' Melian dialogue, where the Athenians tell the Melians, "Of the gods we believe and of men we know. There is no such thing as real justice. Men take what they want, and the strong rule the weak because they can." Now, a very powerful corrective to this idea was offered by Herodotus and the great tragedians, above all Sophocles. Herodotus continues to be taken too easily. He is seen as a mere storyteller, a narrative. Instead, he is the most profound of moral thinkers, who uses history to expound a moral philosophy based upon the idea of justice. He ranges through the entire world, Egyptians, Babylonians, Scythians, to show the strange customs that every society has. But beneath this variety of man-made custom is the unchangeable law of God. Zeus is the chastiser of the evil, and there is one universal law of true morality for all mankind. This idea comes through powerfully in the Antigone of Sophocles, a tragedy we discussed in our earlier lecture, lecture number 4. The whole theme is the law of man versus the law of the gods. And Antigone goes to her death in her belief that it is the duty of the individual to follow his or her own conscience, regardless of the dictates of the leader, the state, or the laws of man. God speaks directly to the individual conscience, and the divine law is the supreme law. As she tells Creon, the law has been made by God forever. You cannot change it. And as Cicero would later say, that law is one and the same everywhere and in all time. Now, for Antigone, it is her duty, not her right, to follow her conscience. And she willingly accepts the consequence, death, for her adherence to the universal law of the gods. Now, Socrates would develop further this concept of the natural law and the law of conscience. And it is interesting that the Antigone will be cited by his tradition as a foundation stone for the idea of natural law. Plato was the greatest student of Socrates, but another important student was Xenophon, who also wrote dialogues about his teacher. And in his dialogue with Hippias, Socrates discusses this idea of natural law. The gods, he tells Hippias, have ordained what is lawful, and that what is lawful must also be just. This is true of the unwritten laws, which are defined as those laws which are uniformly observed in every country. These laws were made by the gods. They include paying reverence to the gods and honoring our parents. And those who transgress these divinely ordained unwritten laws pay a penalty that no man can escape. Plato will develop the idea more fully. And in the laws, Plato establishes the basis for all justice and laws in the belief that the gods exist, that they care for justice, and have ordained laws to ensure it. Law exists through nature and is the product of reason through thought. Now, this Socratic legacy is developed even more fully by Aristotle. And in his work on rhetoric, Aristotle cites Sophocles' Antigone as evidence that a century earlier, the idea of natural law existed. Justice and injustice, Aristotle writes, have been defined in reference to laws and persons in two ways. Now, there are two kinds of laws, particular and general. By particular laws, I mean those established by each people in reference to themselves, which are again divided into written and unwritten. By general laws, I mean those based upon nature. In fact, there is a general idea of just and unjust in accordance with nature, as all man in a manner understand, even if there is no communication or agreement between them. And this is what Antigone in Sophocles means when she declares that it is just, although forbidden, to bury Polynices as being just by nature. And then Aristotle quotes, "For neither today nor yesterday, but from all eternity came these statues, and no man knows from whence they came except the gods." The idea of natural law was given a universal stage by the conquest of Alexander the Great. And in Lecture 6, we discussed Alexander's contribution to the idea of the universality of mankind, the brotherhood of all mankind. And it was in the aftermath of Alexander's career that the philosophy of the Stoics raised the idea of natural law to a universal concept that would pass on to Rome. The Stoics took their name from the very simple fact that they taught in the Stoa, a porch. In Athens, they looked upon their spiritual founder as being Socrates, the man of conscience. Like Socrates, the Stoics believed that true freedom was internal, and thus they were less concerned with earthly forms of government and believed that the true wise man was a citizen of the world. Equally, the law was universal. Chrysippus, one of the most profound and also one of the most religious of Stoics, writes that law is the king of all things human and divine. Law must preside over what is honorable and base, as ruler and as guide, and thus be the standard of right and wrong, prescribing to animals whose nature is political what they should do and prohibiting them from what they should not do. Now, Stoicism was one of the most important intellectual currents for the Romans. Panaetius came to Rome and was the teacher of some of the most prominent of the Roman aristocrats in the 2nd century BC. And Panaetius exercised a tremendous influence on Cicero himself. He is perhaps the most quoted of all Stoics by Cicero. And Cicero's book on moral duties is a long discussion of Panaetius' moral philosophy. And it is again this theme of natural law which unites all of Cicero's philosophical works on politics, providing the foundation for his belief that law is the basis of the state and that God is the basis of the law, and that God reveals his law through human reason. With Seneca, in the 1st century A.D., a Stoic philosopher became the second most important person in the Roman Empire. He was closely associated with Nero for a period he played a role, essentially not only tutor to Nero, but director of policy at Rome. And Seneca placed profound importance on the idea of natural law as a universal binder for mankind. He believed we have a dual citizenship, both a particular citizenship, say in Rome or Athens or Carthage, and then an infinitely higher citizenship in the universal city of mankind and of the gods. and for Seneca, liberty and equality are innate faculties belonging to all men. Because they share the same Creator, master and slave share the same nature. It is fortune, not nature, which makes a man a slave. Slavery is external. It only affects the body. The mind can never be given over to slavery. Now, if with Seneca, a Stoic thinker was for a time the second most powerful man in the Roman Empire, with Marcus Aurelius, a Stoic philosopher king ruled over the immense majesty of the Roman Empire. Love of our fellow man, truthfulness, moderation, these are the qualities of the rational soul. And they are equally, Marcus writes, the qualities of the law. Thus, right reason and justice are one and the same. Marcus believes himself to be by nature a man of reason and a man of civic duty. As Marcus Aurelius, his city was Rome. As a man, his city was the world. As Emperor of Rome, he believed in a government which had one law for all, a government based on individual equality and freedom of speech, and a sovereignty which sought to ensure, above all else, the liberty of the individual. And like Cicero, the Emperor Marcus Aurelius believed liberty to be the greatest good. Now, in the Roman Empire of Marcus Aurelius, the idea of natural law did not remain just a philosophical concept. It was written into the legal code of Rome. And the 2nd century, the age of Marcus Aurelius, and the 3rd century, these were the creative ages of Roman jurisprudence. Of these, none was more creative than the Roman jurist Ulpian. Ulpian would hold the post of Praetorian prefect, second to the emperor in power. His judicial decisions would be codified in the works of Justinian, and the works of Justinian, citing Ulpian, would make the concept of natural law the foundation of Roman law. Ulpian divided law into 3 categories: jus naturale, jus gentium, jus civile, the law of nature, the law of mankind, the law of citizens. Jus naturale was that law which united all men, women, and indeed all creatures. Universal. Jus gentium was the law commonly accepted by all nations of earth. And then relationships between citizens of individual cities was regulated by jus civile. Jus gentium could, for example, recognize slavery. But by the law of nature, by the law of God, all men were born free and equal. But mankind itself had reduced some to slavery, and hence jus gentium regulated the treatment of slaves on a broadly based level. And then jus gentium might regulate the sale of a slave between individual citizens. Thus God saw all men as free. The laws of mankind in general recognized slavery and deprived people of their freedom. And then individual cities had their own regulations for manumitting slaves. Ulpian saw an even higher unity in jus naturale. He said that animals themselves have rights under the law of God. This has irritated modern commentators on Ulpian, and in fact they have tried to dismiss this as an aberration of Ulpian. In fact, the idea that natural law also includes animals goes all the way back to Greek thought. Empedocles describes the law of God as caring for animals and making it wrong by the law of God to inflict unnecessary pain upon any animal. So the law of God in Ulpian includes all of nature, and Cicero himself says that we can tell that animals have a kind of instinct that recognizes obligations, responsibility, and thus makes them part of God's law. So animal rights are not a modern invention. It's something already written into the Roman Code. Paul, the rabbinical student, was also a student of Stoic philosophy. And Paul embodies the concept that the Gentiles have engraved on their heart an unwritten law, that is, the law of nature, and is universal. And through Paul, as well as through the influence of Roman law, natural law would become a fundamental part of Christian thought, echoing down through the Middle Ages until it finds its fullest summation in Thomas Aquinas as the law that binds the entire human community. John Locke, in his 2 treatises on government, would then take the conception of natural law and make it the justification for the political revolution that had occurred in England. Government was founded upon natural law. The rights of Englishmen were but the particular statement of this natural law. And so, on down to Jefferson. So from Socrates and Plato and Aristotle, through Cicero, to Thomas Jefferson, through Locke, a direct continuum in this powerful concept of natural law. Now, the words of Jefferson have become so familiar to us that we ponder today words like life, liberty, and the pursuit of happiness. It seems to me too little. We might go back and try to understand what Jefferson himself meant when he wrote life, liberty, and the pursuit of happiness. And then we might try to take it into our own day and see if we are so easy in our understanding of it. All men are created equal. And yet that raises a fundamental question, because didn't Jefferson own slaves? How is slavery compatible with the belief that all men are created equal and free? Well, natural law had an answer. Natural law, in fact, in the Roman Codex, saw slavery as a civilizing concept. It was argued that in the beginning, mankind had simply put prisoners of war to death, and hence letting them live as slaves was more humane. Or a man fell into such debt, argued the Roman civilians, as they were called, the students of the Roman civil law. A man fell into such debt that his creditors could seize him and inflict terrible punishments upon him, even cutting away a pound of his flesh. And so allowing himself to sell himself into slavery was more humane. Or thirdly, a man reached such a state that he could not care for his children, and hence he sold them into slavery as preferable to allowing them to starve to death. So this concept then of natural law showed how men had taken the ordinance of God and for what they saw as humane reasons created slavery. So throughout the history of natural law, slavery has been compatible with the concept that all men were created equal. The careful French thinker Montesquieu, in his Spirit of the Law, was unimpressed by this argument. He said that slavery was a moral wrong, and it was utterly absurd to try to justify it in this fashion, that men should not kill prisoners of war regardless, that it was better to lose a pound of flesh than to be sold into slavery, and the state should take care of children whose parents cannot afford to take care of them. But by the traditional thought of natural law, Jefferson could have argued that there was no contradiction. But he knew there was. He knew slavery was a great moral wrong, and the later part of our lectures will be given over to how this great moral wrong was eradicated from the true tradition of freedom. And what do we mean by life? How do we have an unalienable right to life? For Aristotle, it was clear. It is wrong to commit suicide. This is also the view of Socrates. God has given you your life, and you cannot throw it away. You can hope for its end. You can look forward to death, but it is wrong to take your own life. Stoic thinkers like Seneca disagreed. They saw in suicide the final act of a free life. But the unalienable right to life remains a question for us today. When does life begin? It is the most serious moral issue facing our country. And we as a nation, we as the human race, have not agreed on what is an unalienable right to life. Liberty? How do we define it? Well, I think Jefferson would have pointed with good reason to the harmonizing sentiments of his day. The definition of liberty was well accepted, I think, by Tories and Whigs, on the continent as well. And we find perhaps our best definition, in terms of the harmonizing sentiments of Jefferson's day, in Cato's Letters. These were a series of newspaper articles written in the first part of the 18th century by John Trenchard and Thomas Gordon. And they became one of the foundations, the staples of the literature of liberty. When one of the early firebrands of the Revolution, Josiah Quincy, died, he left his letters of Cato, as they were called, to his son, with the admonition, "May the spirit of liberty be upon you." And these letters, Cato's Letters as they are called, named after the great Roman patriot who defied Caesar, define liberty as the right to live as you choose as long as you harm no one else. It is freedom to live your life, to enjoy the fruits of your property, to do what you know to be right without being obliged to do something you know to be wrong. So upon this concept of freedom, I think we would be generally agreed as life and liberty. Freedom to live as you choose. But Cato's Letters, and I think Jefferson as well, go on to add to this. For Cato's Letters, it is a fundamental denial of freedom to be restricted in your actions when you do something that harms no one else. So we wonder how an 18th century Whig, the authors of Cato's Letters, or Jefferson himself, might respond to laws about secondhand smoking, or the demand that we wear seat belts. Are we really harming others? In fact, in an effort to reduce the idea of government intervention to an absurdity, Cato's Letters say, what if we went to the extreme of having every person looked after by a national college of physicians? Now that would be true lunacy, the idea that it's the government's prerogative and need to take care of people's health. Surely that must be the individual's decision. But we have moved very far from those notions, very far from Jefferson's concept of liberty and pursuit of happiness. When we looked at the Declaration of Independence, we saw how the concept pursuit of happiness was chosen specifically by Jefferson. Not property, but the pursuit of happiness. The mandate that we follow lives that are of benefit to ourselves and to the community. Natural law is also founded on an ideal of universal truths and absolutes. Absolute right and wrong, absolute justice. These are concepts we no longer accept as a society. As a society, we believe that actions and values and what is right and wrong is determined by the circumstances, that there are no absolutes. So it challenges the very concept of natural law. In fact, it denies the essence of natural law. And to speak of the law itself, for the great jurist Blackstone, natural law was expressed through the common law. No law could be a true law if it violated reason, justice, or common sense. But to us as a society, the law is not a set of absolutes, but a set of tricks. And yet it was in the diverse, multicultural empire of Rome, with many sets of religions, philosophies, and ideas, that natural law, based on absolute truth, provided the binding nexus and that set of shared values essential to the survival of a free nation. And natural law offers that same challenge today if we have the courage to grasp it.